Obama's Detainee Dilemma, next on International Focus.
The Institute of World Affairs at UWM and Milwaukee Public Television present International Focus, a global magazine linking Wisconsin and the world.
Welcome to International Focus. I'm Doug Savage, Assistant Director of the Institute of World Affairs at UWM. Among Barack Obama's first acts as president was an executive order calling for the closure of the prison facility at Guantanamo Bay by January 2010. Closing the facility has proven easier said than done, however, raising a host of thorny questions about the legal status of detainees in U.S. custody. To help us explore the sometimes uncharted legal waters around Guantanamo and some possible resolutions to the detainee issue, we're joined in the studio by Robert Beck, Associate Professor of Political Science at the University of Wisconsin-Milwaukee, where he specializes in issues of international law. We're also joined by phone by Marisa Porges, a Council on Foreign Relations International Affairs Fellow and former policy advisor in the Department of Defense's Office of Detainee Affairs. She also served as an aviator in the U.S. Navy. Well, welcome both of you to International Focus.
Thanks.
Thanks. Good to be here, Doug.
Well, Marisa, maybe we could start with you. I'm wondering if you could give us some sense of the various legal status of some of the detainees. I mean, we hear about lawful combatants, we hear about prisoners of war, we hear about unlawful combatants. What's the difference?
Yeah, it's a very complicated situation, Doug, and it's one that's been debated since Guantanamo opened and is still largely unresolved, actually. It's part of the reason why Senator Graham has called Guantanamo a, quote, legal mess. In very basic terms, and this is coming from a non-lawyer, so I tried to make it as simple as possible. The term that's applied to the individuals at Guantanamo is sort of how the administration wants to apply the law of war on the ground, specifically the Third Geneva Convention, where the term prisoner of war was first defined. And what has been called at times in the Guantanamo context lawful enemy combatant is really just a prisoner of war, a regular soldier, someone who's a member of a military, wears a uniform, operates under declared laws of war, and therefore when they're captured is privy to the protections of the Third Geneva Conventions. They can be held to prevent them from going back to the fight and taking up arms again, but they must be given 3 meals a day, medical treatment, things along those lines, and also the right to contest their detention. There's also, further issues about interrogation tactics and things like that that will come into play later when we're looking at the Guantanamo detainees. So that's the background there of the term prisoner of war or lawful enemy combatant in the Guantanamo context. And it's been used in the past by the United States, even in the first Gulf War, where the military conducted almost 1,200 hearings to review the status of those that were being held, and in fact, hundreds of detainees were released when they were found to be innocent civilians. Now we come to immediately after September 11th, and even when at the highest levels of the administration, the Bush administration, that is, there was debates about it. It essentially appears that the most expeditious solution was the one that won out, and one that gave more freedom of movement with interrogation tactics, and which limited the legal rights of those that were being held. And so the choice was made to go with the term unlawful enemy combatants. And it also was a rhetorical distinction to highlight the fact that those being held were members of Al-Qaeda and Taliban, so we're not normal soldiers, we're not wearing uniforms, we're not part of a state institution signed up to the Geneva Conventions. That's complicated enough to begin with, and for those of us who didn't go to law school and aren't privy to, all the details behind that, it seems like that should have been, as murky as we needed it to be, but over time, the ball of not got tighter and more hard to unwind, because essentially when that term was contested through a number of court cases that were trying to debate whether or not the detainees at Guantanamo had the right to appeal their detention. The first one being in the Supreme Court in 2004, Rasul versus Bush, which determined that the prisoners there did have habeas corpus rights. Then more after that, in the fall of 2006, when there was a case at the Supreme Court level, Hamdan versus Rumsfeld, which reviewed the military commissions cases in terms of how that review process for detention was being enacted. Again, over time it's gotten more complicated, and we've seen the term migrate. The term initially was unlawful enemy combatant. It later became straight enemy combatant. And most recently, under President Obama, last March, it became, they dropped the term enemy combatant. And now it's even a murkier situation, and yet it doesn't actually change anything from a practical standpoint, which is the most interesting thing. In practical terms, nothing's really changed. There are still habeas cases being brought through the federal courts. In fact, a Yemeni detainee just lost one last week at the U.S. Court of Appeals. But the overarching, rhetoric involved, it paints a very murky picture, and it makes it hard to explain to the international community, much less the American public and everyone else involved, what is going on and the legal ramifications for the U.S. upholding these individuals either on Guantanamo or in the United States.
I'd like to pick up on one point that Marisa made with respect to the rhetorical dimensions of this, and it's a rhetorical irony, and that is that on the one hand, the Bush administration was happy to use the W word of war, global war on terror, which many critics challenge as an inappropriate use of the term war, and yet on the other hand, they were unwilling to embrace prisoners of war. So they were happy to use the rhetoric of war when it served political needs, but were happy to also reject it when it raised potentially problematic legal dimensions.
Well, and Marisa, is the real practical upshot of that distinction access to alternative forms of the criminal justice system?
Yeah, I mean, that is getting to the heart of the situation for the legal ramifications. As I mentioned, there's been some discussion about the effect it had on interrogation tactics that were used on detainees in the early years. But for the conversation we're having now, yes, it does play out in terms of what access the detainees were given to the justice systems and how they were able to contest their detention. It's interesting, though, because in a lot of ways, the military commissions that were developed as a result of the Supreme Court cases and all this discussion over unlawful enemy combatants or lawful enemy combatants, prisoners of war, etc., it was mirrored after the Article 5 hearings that are given to prisoners of war, the ones that in the Gulf War or prior to that, and in some ways they have more rights in the military commissions that have been established under congressional law, that the enemy combatants are given not lawyers but representation to help defend their detention, defend themselves in the light of detention. But the overarching shadow of the initial decision by the Bush administration has haunted those efforts and made them largely ineffective to date.
Well, let's jump forward to the present, if we could. Now, we've got some population of people detained. The administration, the Obama administration, has clearly made closing the facility a priority, and yet it hasn't been able to do so. So what are some of the issues preventing us from just shutting the gate and calling it a day?
Well, and that's almost, that's probably more complicated than the legal issues we just described. It's a multi-layered problem. We've heard President Obama state from the very beginning that there was going to be different types of detainees and different approaches taken, some to be prosecuted, some to be transferred, some to be held under continued detention or, with the military commissions. And those are all still true, and yet a few of them have come to the forefront and really forced the hand of everyone involved and forced the administration to come to the realization, or at least publicly admit, that there's no way they'll make the deadline initially set out by the president, which was an aggressive deadline to start and was largely part of a public diplomacy effort with the international community and to push the individuals involved, push those working the issue to move forward on it as quickly as possible. But to get back to what issues are at play still now, first of all, there's the overarching issue is what to do with dangerous individuals we have in our custody that can or cannot be prosecuted. The question of do you bring them to the U.S. or do you keep them in Guantanamo is the first overarching concern. Bringing them to the United States, people are concerned, administration has been concerned, and a lot of lawyers are concerned that that would open up U.S. Civilian courts to the detainees in a much larger way than it has been already, and that would pose potential issues down the line in terms of having the government be forced to release some of the detainees when they lose their cases in civilian court. So that's part of the issue. Legal impediments and security concerns as well that have been raised in terms of bringing individuals to the United States. There are counter arguments to both points, which are very important to remember. In regards to the legal issues, these cases have been ongoing. The habeas cases are still ongoing in federal court, and there's individuals that we being the U.S., that the U.S. has been forced to release in the past. And it's not that they, if we're in the United States, would walk freely on this corner of whatever city or they were being held in. They would likely be held under immigration law until they were transferred out or found a suitable destination. The same thing that happened with detainees at Guantanamo after the habeas case was lost by the administration. And regarding the security concerns, there are over 200 high security inmates currently in custody at the Supermax facility in Florence, Colorado, a number of which have links with international terrorists. Richard Reed and Ramzi bin Yusuf, and names what when in the those studying counterterrorism or terrorist issues, they've been linked to international terrorist organizations for years and have been there, and there's never been a breakout. There's never been a security concern with that, and so to a large degree, that isn't necessarily a valid concern, and yet it goes more to the overarching problem of the domestic issues at play with closing Guantanamo. We have the international issues of trying to get other countries to accept their detainees, but moreover, we have the domestic issues of resolving from a standpoint of the American public what is an acceptable outcome and where these detainees should go. And so that's just a snapshot of the issues at play, but they're all intertwined, and as we've seen in the past few weeks after incidents in Yemen, unrelated incidents can very quickly come back to what's happening with Guantanamo and what's going on with the detainees there.
Well, right, and I think it's yet another example of how the domestic policy often can drive things of a more international focus. Well, we're about to take our break. Marisa Porges, Council on Foreign Relations, I'd like to thank you for being with us, and to our viewers, we'll be right back with more International Focus.
The Institute of World Affairs presents our community with a range of public programs relating to global issues, U.S. foreign policy, and the world economy. For more information about the Institute of World Affairs, call 414-229-3220 or visit our website at www.iwa.uwm.edu.
Welcome back to International Focus. We're talking about Obama's detainee dilemma with Robert Beck, of the University of Wisconsin-Milwaukee's Department of Political Science. Well, Bob, anything in particular you'd like to highlight from what we just heard from Marisa?
I think she raised a number of very important points, which I would underscore. As you were saying before the break, the domestic and international dimensions of this problem, I think, are both notable in terms of the challenges that are posed and the opportunities that may be there. I think another point that bears some emphasis is that contrary to probably the general public's understanding, there already are perhaps as many as 350 alleged terrorists who are incarcerated within U.S. territory. So the proposal in mid-December by the Obama administration to bring perhaps 100 or so Guantanamo Bay detainees to the Thompson facility in Illinois doesn't really do anything dramatically new. The terrorists are already here. And I think a third point that bears emphasis is just how extraordinarily complicated and difficult the situation is that the United States faces now, and it I think shows the law of unintended consequences. I mean, the United States moved along on this road toward detaining hundreds and hundreds of unlawful combatants or unlawful enemy combatants, or however you wish to characterize them. But now we have them, and there aren't a lot of attractive options. As Marisa said, they can be tried either by a military tribunal or commission or by U.S. courts. We can seek repatriation, and in fact, many have been repatriated or resettled. But in both those cases, the states have to accept them. And of course, if they are repatriated or resettled, there's a real recidivism problem, depending on who you believe. 1 out of 7, or maybe half of those who leave incarceration or better said, detainment will recidivate. So you have those alternatives. You could also, and she didn't have an opportunity to speak to this, but there is sort of a de-radicalization or retraining that the Saudis have sought to assist in, but that also raises problems. And then we're sort of left with an ugly but perhaps inevitable option, which is what is sometimes called preventive detention or non-criminal detention. But that rankles many civil libertarians who feel like the apparently indefinite incarceration of individuals who have never been tried for a crime runs afoul of American rule of law.
So just how far into sort of uncharted legal waters are we with a lot of these issues?
Well, much of this is really new. I mean, there were 3 Supreme Court cases to which Marisa alluded that addressed these unprecedented circumstances, and should the Guantanamo Bay detainees, the 100 or so that are thought to be brought potentially to Thompson, should those be brought here? There are all sorts of questions about the statutory authority to detain them. There is no domestic statute that would actually authorize this. The Congress would have to somehow pay or authorize to pay for this to happen, and that hasn't happened yet.
Well, and in fact, wasn't that part of the rationale for setting up the facility offshore? That that there's precedent that says if they're not physically within the U.S. sovereign territory, they're not subject to the U.S. criminal justice system.
And you have an existing U.S. naval facility that you can draw upon. So this is a brave new world, and I think it underscores a point we spoke about before the show today, Doug, and that is that a law often lags behind the situation on the ground. And as the international law panelist today, I would say that the whole structure of international law that deals with terrorism is about 60 years behind schedule or so, and was really designed for conventional conflicts where you knew who the combatants were, you knew their nationality, you knew when the war began, you knew when the war ended, and really none of modern terrorism tracks along those lines. So you have to do a bit of legal jiu-jitsu even to fit those who are detained into any existing category.
Well, and that brings up a good point. I mean, in previous conflicts where there were prisoners of war, there was a universally recognized end of the war, at which time the prisoners were repatriated. Now, when do we know if the war on terror is over?
And that's really a huge problem. I mean, even under the current detainment in Guantanamo, based on the most recent Supreme Court cases, the authority to detain will only last under the logic of the Geneva Conventions until the armed conflict ends. But how is that defined or determined in an authoritative way? That's not clear. And I think that will ultimately, be in part a politically determined outcome, but it may end up being another thing that the Supreme Court is called to render a decision upon.
And has there been sort of a consistent trajectory on some of the relevant Supreme Court findings in these cases?
The court has, I think, fairly generously interpreted what's called Common Article 3 of the 1949 Geneva Conventions. There's a lot of argument about really what is the proper scope for jurisdiction of the Geneva Conventions. And Article 2 says essentially a state-to-state war or a declared war, the Geneva Conventions apply. But under Article 3 that is common to all four of the conventions, many people think it really was designed to deal with civil war. It's essentially a circumstance of armed conflict within a signatory state. But the Supreme Court has suggested that Article 3, Common Article 3 of the Geneva Conventions can be held to apply to the current circumstances. It's sort of a none of the above category.
And so what does that mean in terms of
that means that the protections accorded to combatants can be applied even under a circumstance that is arguably not an Article 2 conventional war that's state to state. And without getting too arcane, one could argue, and some have argued, that because we don't have a good old-fashioned war, and because we don't have really a civil war within a given state, that the Geneva Conventions don't apply at all. And the Supreme Court has said that they do apply.
And wasn't that really one of the most contentious aspects of this during the Bush administration, whether or not they did apply?
Yes, that's exactly it. I mean, and again, to put it at its most simple level, the Bush administration's argument was these are not prisoners of war, and thus we can treat them without the normal provisions that would govern prisoners of war.
So is there any historical precedent for someone who is being detained but isn't legally and formally a prisoner of war?
I think the scope and publicity of the detainment here is what's most striking. There certainly have been detentions, but I think that aside from the scope and publicity of this detainment, is just the radically changed nature of the circumstances, the so-called war on terrorism, which is really, I think, generating all sorts of new law and probably generating various tenures and promotions among law professors and political scientists.
Well, we see a new administration, some new sort of chief legal minds at work on all of this. How has the Obama administration's approach differed from their predecessors?
Well, I think there was great optimism that with a new administration there would be a radical departure from the past, and indeed, as you've noted, the first week of the Obama administration came the order of that within a year there would be a closing down of Guantanamo, but that was a tall order, and many have, I think, felt disappointed at the incapacity of the administration to bring that about. But I think that they were unduly optimistic, didn't appreciate the congressional opposition that they would face. They had, I think, greater hopes that other countries would cooperate. They, I don't think, communicated as well as they might have. So to a fair extent, there's still some degree of continuity between the Bush and Obama administrations, at least to the extent that the Obama administration is going to be stuck with this problem of detaining without the context of criminality.
So for some percentage of the people, we have no proof of criminal behavior, but no place to put them. So essentially, they're the Count of Monte Cristo and the Chateau d'If. They're just thrown away the key.
Well, they could probably not be successfully tried in a federal district court, perhaps not in a military court either they wouldn't be successfully tried, or there would be issues of confidentiality with respect to evidence. Just the capacity to gather evidence is much more difficult. So these folks could probably not be successfully tried, and yet by various counts, there's 90 to 100 of these folk who are not deemed to be safe to be released into the general population.
Well, Robert Beck, professor of political science, thank you. To Marisa Porges, who we heard from a bit earlier, thank you as well. And to our viewers, we'll have to keep an eye on this one. We'll see you next time on International Focus.
For information about the Institute of World Affairs and its many programs, or to become a member of the Institute, call 414-229-3220 or visit us at our website,